Hi everyone, welcome back to my channel. Thank you so much to the new subscribers. I really appreciate it. I started this channel doing classic book reviews and I plan to go back to that, but right now I'm a little bit obsessed with the Chad and Lori Vallow Daybell case, and so today I want to talk about the alleged conflict of interest that's going on in this case. First caveat. This is just opinions, guys. This is just a video of speculations, a video of opinions, a video of woodshedding. It is not facts. It is not going to paint anybody to be a good guy or a bad guy or slander or libel anybody or anything like that. So let's get into it. These cases in Lori Vallow Daybell and Chad Daybell and all the shenanigans that have gone on with this alleged doomsday cult, these cases are more than likely going to all end up in front of Judge Edens in Idaho. And just to give you a backstory, Chad Daybell is right now catching charges for having the two dead bodies of children, of Lori Vallow's children, on his property. Those are the most pressing serious charges he's caught so far. Lori Vallow didn't report her children missing, okay? So she had some misdemeanor charges for that. Now, we know where the children are, but the state is seemingly shaping a whole entire conspiracy theory against these two defendants, and that's going to be a case that's going to be blended together, all right? Similar instances, similar fact patterns, all right? So that's what you got to keep in mind when you're thinking of conflicts of interest. Allegedly, whenever Mr. Means, Attorney Means, showed up in court on behalf of Mrs. Lori Vallow Daybell, the prosecution took note and said, hey, wait a minute, Judge, I do believe Mr. Means had represented Chad Daybell in a previous hearing, and I could be wrong, and correct me if I'm wrong, but I believe it was the bond hearing for Chad. And there was a little bit of debate about it, and essentially the judge said, you know, let's work it out. It was the end of the hearing. Let's work it out, figure it out. And it come to find out that yes, there was a conflict, otherwise it wouldn't be waived. So the judge is accepting a waived conflict of interest, and this is what I really want to dive down deep into and make it a little bit understandable to the layperson as to why is this important. Second of all, no shade to civil attorneys, all right? No shade at all. But there's a reason you have, you know, attorneys that kind of specialize in civil cases and civil matters, and then you have attorneys that kind of specialize in criminal cases and criminal matters. It's the same thing as like a doctor. You can go to a general practitioner who can take a splinter out of your toe and give you something for your kidney stones and, you know, fix your strep. And then, you know, when he sees, oh, they need psychiatric help, he sends you off to the psychiatrist. Oh, they got sciatica, well, they send you off to the proper specialist for that. You know what I'm saying? Can a doctor prescribe things? Yeah, sure. Can an attorney represent, you know, can one that does civil cases and contract law do criminal court stuff? Sure. But don't you want a specialist? And don't you want a specialist when it's something as important as possibly murder charges? So just keep that in mind. That's the second thing I want you to keep in mind. The first thing is conflict. The fact that we're talking conspiracy. We're talking same circumstances, same dead folks, same defendants or group of defendants. And then you also have the fact you want to have the attorneys be the proper kind of attorneys representing their clients. You know, they have a duty to represent their client. You have to do that. It's an oath you swear that you will zealously represent your client to the best of your ability. That is your sworn duty as the attorney. So, as of today, we'll call him Attorney Means, is representing Lori Vallow Daybell. All right? But he allegedly represented Chad Daybell, and I believe it was in his bond reduction hearing. I could be wrong, but it was a recent thing. It wasn't as if As far as I know, he represented Chad Daybell in a dog bite incident 5 years ago. And now Lori's got her, I want to say tit in a sling, but Lori's got some serious problems, and now he's representing Lori. That really wouldn't be a conflict of interest. You know what I'm saying? But now we're talking conspiracy, similar incidents, similar people, similar dead folks. You're at the same places. All right? You don't want the same attorney representing two people that could at any point have divergent interests. And I'll fully explain this. So in my opinion, this is the classic conflict of interest case. I mean, classic. You could open it up, and as it stands now, unless there's some other detail I don't know, this is the classic conflict of interest where you have two defendants whose interest at any point can turn against each other. And you cannot have one attorney representing two clients that could then be going against each other, because then you'd have to choose or make a decision for one that wouldn't benefit the other. You can't have that. Here's the little mini rub, is it in the law and in religion, it's always viewed that marriage is like a union, right? And in many ways it's viewed as marriage is like a one person. In marriage, you're a union, you're one person. Fine. For some instances that's true. But not when we're talking about felonies, and we're talking about children that are being buried dead on properties and who was where. You know, who buried this and who did that. Now we're talking about two people catching their own charges, right? We're not talking about a union. We're talking about two different people that at any point could turn against each other. And you can't have an attorney, even though he's not at that point representing them both at trial, he can't have knowledge about that stuff that he represented the one and now he's representing the other. That's a conflict, and I'm going to give you some reasons to explain why. But first, why do you care? Well, let me tell you why. Because if you have a conflict of this kind, it can be an appellate issue. It can create an appellate issue, and it would get reversed. So you would go through this whole entire case, and they would have this ace in their sleeve of this appellate card because there was this horrible conflict of interest. And guess what? You'd have to try the case again. You know, and that's the last thing you want to do. It wastes time. It wastes resources. It's just a bad idea. You want your trial to be as clean as possible. The judge wants his trial, his record to be as clean as possible. He doesn't want to be overruled on appeal. The prosecution doesn't want to be overruled on appeal. Nobody wants to be overruled on appeal, except for maybe the defense attorneys. They're like, yeah, fine. This works fine for me. This works fine for me. So that's one reason why the defense attorneys really don't tend to care in this case, because it gives them just another thing they can use later. So like I said, each attorney has a duty to his client to zealously represent that client. And two defendants have two separate interests, all right? They're not one person. And as you're an attorney, you're not supposed to be dividing your allegiances. And an attorney who, even though he's not representing this one anymore, but is still representing this one, but knows the information this one knew, he has an ace up his sleeve. He has an ace up his sleeve against this one. And let me kind of explain why, all right? Let me explain in some generalities, and then I'll paint you some ugly pictures prognosticating. Okay, how can a defendant get screwed by this? Well, the attorney could use, like, say, statements they gave to them legally. You can call it attorney-client privilege, and end up using it for one defendant against the other. Stuff that would say never be discoverable to the court, but the attorney knew, and then he ends up using it for the benefit of the other. Like knew something against Chad, or that Chad said or did or saw or whatever, and then knows it and uses it to benefit Lori. That would be horrible, and that would be reversible if it came out. Like I get all the time, they give their attorney confidential information that is just between them and their attorney. and the attorney could favor the client they have right now, and that's not good. And even though they're happy right now and they're married on the astral plane, and you know what I'm saying, forever and eternity, and they're soul joined, doesn't mean that they're always going to stay that way. You can sign waivers saying, oh, we're fine with Mr. Means. I love Lori and Lori loves me. You know, Chad loves Lori and Lori loves Chad, and they're both signing the waiver. But, you know, you don't know down the road how they're going to feel once people start flinging things against each other, and information comes out and the end of the world didn't come and all this stuff, and you start thinking somebody's a fraud, right? It can become adversarial at any moment, and that is the exact thing that you want to guard against. You want everybody to have their own clean attorney. So, allegedly, Judge Edens ruled, quote, any conflict of interest has been adequately waived for the current proceeding. Let's break that down, shall we? Adequately waived. Can we break down that? Adequately waived. And I put laugh out loud on my notes. Let's talk about adequately waived. Let's say you have an attorney doing your estate planning. You know, you have your family attorney, and he does your estate planning. And you have, because commonly husbands and wife do them together, and that's not a conflict of interest. But let's say then you get divorced, all right? We had this at one of our firms. Oh shit, we had this all the time. You have a family, they come in, everybody gets their estate documents done, and then they get divorced. And one client really wants to stay with you, and the other client, with love and kisses, goes elsewhere, because you cannot, in a divorce, be representing both the clients. During the marriage, and for people agreeing how these are our assets and this is how we would like to distribute them with the family, that's fine, because they're one unity. They're not going against each other. But the minute they're talking about post-nuptial agreements, they need separate counsel. Doesn't matter how much they love you and you love them as an attorney, or they love each other. You've got to keep an eye out for your client's best interests, and know that at any moment they can turn on you like a Rottweiler. They can turn on themselves like Rottweilers. Oh, nothing against Rottweilers. I'm just using Rottweiler as an example. So you can have them do waivers and all that sweet stuff, but you got to protect yourself. You got to protect them against themselves. So, any conflict of interest has been adequately waived for the current proceedings, is what Judge Edens allegedly has ruled. For the current proceedings, let's focus on those words. Does he mean the pretrial proceedings? Because we're in pretrial. And I'd agree, it is pretrial. However, a case can be won and lost in pretrial proceedings, guys. Won and lost. Think about evidence. I know some great evidence attorneys, like they specialize in evidence, and they can win a case in pretrial proceedings by getting the evidence kicked out, by knowing every single thing about that damn evidence code, because they're criminal attorneys and they know every single thing, and they can get that evidence kicked out before you even get to trial. Then there ends up not being a trial because there's scanty evidence. So I'm just saying, just to wait until the trial is actually start and you're doing voir dire, that's a little too late. This is my opinion. As a former paralegal, this is my opinion. Okay, now, if you wanted to say, and this could be the case, that the only time that Means met with Chad was maybe through the telephone. Maybe Chad contacted Means and said, hey, can you represent me just for a bail reduction or whatever? Here's the money, we'll put it in your escrow, and they discussed nothing about the case. De nada. They discussed nothing. Nilch, okay? And he knows nothing. He knows nothing about what Chad thought, did, said, knew about Alex, the cult, nothing. All right? That would be one thing. That would be acceptable for the current proceeding. But going forward, knowing that there's a conspiracy being charged against these folks, enough is enough. Why wait? Why wait until the murder charges are levied to then say, sorry, Mr. Means, you need to get off of Lori Vallow's representation, because guess what? You represented Chad. It wasn't, like I said, it wasn't for a dog bite 10 years ago. It was for something recent. So, here's what I'm speculating. So, hello, guys, if anyone wants to get critical. This is speculation. So, listen, speculation. Here's what I think happened. You have Chad and Lori, they're in Hawaii, right? Who's got the money? It's not Lori. She didn't get the life insurance payout from Charles Vallow. The one that did was poor Tammy. Her life insurance money went to Chad. It was like $430,000. So he had some money, and they went to Hawaii, and they were doing luau and you know, the whole 9 yards with the ukulele and the professional photographers and all that good stuff. And then all these charges start coming, and Lori's starting to get, you know, extradited back. And then this is before the bodies were found. Okay, so we've got means secured as an attorney. Again, he's allegedly not a criminal defense attorney. It could have been someone that Chad knew. I don't know how he got means. I don't care. Means could be wonderful. I'm not dissing means. All right. I'm guessing a retainer was put down. All right. And I'm guessing he was representing the both of them at the time. This is my supposition. All right. And what happened was, in my opinion, then Chad, the bodies were found, and then Chad went and got himself a criminal defense attorney prior, correct? All right. So Chad goes and gets himself a good attorney, one that's allegedly maybe perhaps more suited for the criminal defense arena. All right. Meanwhile, you got a retainer at the Means Law Office, correct? I mean, this is speculation. And Lori's still sitting there needing work, right? So he's representing Lori. They're thinking, oh, it's separated now. It's good. It's fine. No conflict. Well, the problem is there is a conflict because you did represent Chad. In my opinion, I'm thinking, in my opinion, when Chad caught the serious charges of the bodies being found on his land, he went and got another attorney, leaving Lori still being represented by Means with maybe money in escrow. You know, that's how it goes with the criminal defense attorneys or with the defense attorneys. You put the money on a retainer, you know, and then they just start using it for the different things they do, for the different motions they file, for attending the court, whatever it is, for taking your phone calls, the whole thing, you know. And see, I think that's how it went down. I think Chad's the one with the money, and Chad has got himself another attorney, and Lori's left with the retainer using it up with Means, you know. And maybe Means never really spoke to Chad about the crimes, alleged crimes. And so if that's the case, and that makes sense, why didn't Means just say that when the prosecution called him out on the court, right in court, called him out on the floor? Why didn't he just say, "Oh yeah, Your Honor, I was secured. The representation was secured over the phone, and money was put into escrow, but I never met with the client." Well, maybe that would be giving out personal information, so we had to do it behind the scenes. Maybe that's why. I don't know, but still, I mean, did Means really ever represent Chad? Because he allegedly did stand up and say that at one point. Usually you know it when they file what's called a notice of appearance. There's a case, you know, is assigned, and the attorney of record will file what's called a notice of appearance, and it lets everybody know, hey, I'm representing this person, and, you know, here's my contact information. It's at the very bottom by their signature and all that good stuff. So they know that if anything further comes along, that's the person that needs to be spoken to, la-di-da. Right? I don't think he filed a notice of appearance anywhere for Chad because I think he stood up, he just was there in court. And that's fine because you can always file the notice of appearance later. But here's what I want to say. Come on, folks. You know, I know it's Idaho, but I also know that there's a lot of attorneys everywhere. And yes, you know, they're not the most beloved couple on the planet right now, but there's always somebody that wants to make their bones taking a case like this. And so I'm sure that there's somebody else that'd be willing to represent Lori Vallow Daybell in court, okay? You know. So allegedly, as it stands right now, Means is no longer representing Chad Daybell in any capacity. And I have to say, so what? So what? Because you did represent him before in some kind of capacity here recently, and it wasn't a dog bite case as far as I know. It wasn't a traffic ticket. Nope, it had something to do with this. You know, even if it was bond reduction, and the appearance of an impropriety is an impropriety, you know. So just let it go. That's my opinion. Be like Frozen and let it go. You know, one doesn't start to represent a client when the charges are laid against them. They don't start representing the client the minute they hit the courthouse. They represent the client when the client calls, or you call, you know, when the client calls you and you both have an agreement that They're going to be your attorney. You know, sometimes the retainer's put on file, sometimes not. And it's alleged, I think the judge said, if murder charges are levied against either Chad or Lori, that then Means would have to recuse himself or to be removed from the case. But, you know, my question is, why wait? Why wait? I mean, you know it's coming, so go ahead. Then let's prognosticate. I'm going to put on my Miss Cleo fortune teller hat and say how ugly this could get. This is what we don't want to happen. All right, let me tell you. Here's Lori. We're in trial. Things have gone awry for her. Bad things have come out. Cell phone records, texts, you know, people making witness statements about, you know, this, that, and the other. So she turns and says that Chad has manipulated her like Charlie Manson, that he, you know, he's brainwashed her, you know, he lied to her, and that he brainwashed Alex, and that he and Alex are the ones that killed the kids, and that she was terrified of them, and she didn't have anything to do with it at all. You know, that she's just this brainwashed follower, and that, you know, maybe she found out about it after the fact. Okay, so let's say Lori gets to that point, right? Because the end of the world didn't come on July 22nd. So maybe she's a little sour. She's sour that the guru didn't come through. So let's say Chad then realizes that it's going to get laid at his feet. So he says, oh, Lori and Alex Cox, her brother, you know, they're the ones that killed the kids, and they came over to bury something, you know, at my house, but I thought it was, insert anything. I thought it was money. I thought it was her dead pet. I didn't know it was her kids, and, you know, whatever. You know what I'm saying? You know, look at the cell phones, you know, whatever. So then Chad turns against Lori, right? In this case, in this scenario that I'm making up for you, Lori's attorney would be Means, and Chad's attorney would be maybe Pryor or whoever else he has, right? Okay. And the Means would be being paid by Chad. Yeah, I know. So now listen to how ugly this could get. What if Chad had met with Means and told him things like, yeah, this is where we buried the kids, and this is the utensil we used to dismember the kids, and this is where we put the utensil, this weapon. And then Means is sitting there representing Lori, knowing. Now let's say that Lori sat at the condo and didn't know who chopped who up, and where, who got burned where, and where they bought the gas. And let's say she was truly ignorant of that. But let's say Chad had told Means that already in the previous representation. Now Means has an ace up his sleeve against Chad. Think about it. That's the kind of stuff that you want to avoid, that kind of conflict where all of a sudden things are known that shouldn't have been known. Things that were confidential between attorney and client now are not confidential and used as a weapon. You know, in my state, it would be a conflict. It probably would not be waived. Also in my state, if things are even death penalty crimes, you cannot be the lead attorney on a case unless you're death penalty qualified. You can't just go out there and be a general attorney, you know, doing traffic cases and speeding cases and drunk driving. Well, that would be criminal. But I mean, you can't be doing, say, contract law and have no experience doing death penalty cases and then try it as the lead counsel. Could you be on a dream team? Sure. But you have to have experience and you have to have some specialization. And so, I mean, I think that in the best interest of all this, it would be best for them to have criminal defense attorneys and to definitely not have any kind of conflict starting at the very beginning of this case, because the judge wants a clean record. The prosecution wants a clean record. They do not want to be overturned on appeal on something that would just be classic conflict of interest. So, I suggest that you can cure this conflict by simply removing Mr. Means from the case. No offense to Mr. Means.